Did you hear my question?
If you're close to somebody, you need to get away because there's feedback.
Mm-hmm.
When mother and daughter both move to avoid feedback, Patton and Judge Manning come to a realization.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
What happens when the people sworn to uphold the law, or those who stand accused of breaking it, completely lose control? Today, we're diving into 3 shocking courtroom moments where authority collapsed, with dramatic and often unexpected consequences.
Miss Ollie,
Stop talking. Miss Ollie, stop talking. Absolutely nothing you say is going to help you right now. Miss Patton?
Your Honor, based upon that, I would object. I think it still stands. She hadn't even stayed with the conditions as are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
I can feel my blood pressure going up. Wait a minute. Miss Ollie, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions.
To you and lied to you.
Miss Ollie.
Absolutely nothing you can say. Miss
Try to
Rhonda does not want you to
Miss
say
Ollie.
a word. It is not going to help you. So, Miss Rhonda, I tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ollie. And then put it back on for another motions hearing.
Your Honor, I do appreciate that chance.
Thank you, Miss Rhonda. Best of luck to you, Miss Ollie. Have a good evening. But you need to leave where you're at.
2 months later, Judge Manning agreed to modify the bond and allow Ollie to move back in. Our next stop is at the Fayette County Justice Center in Fayetteville, Georgia, where 24-year-old Ronard Neal, seen here, appears before Judge Fletcher Sams. Neal's in court today to face previous charges of theft and fleeing officers. But there's one big problem. He was supposed to be there yesterday, but didn't show up. So after a bench warrant was issued for his arrest, Judge Sams orders deputies to take him into custody for failure to appear. But Neal has other ideas. He tumbles into an adjoining courtroom packed with shocked onlookers as he runs through and damages a door. In the hallway, he runs into deputies, including one who desperately tries to hold on to him. But Neal escapes down a stairwell toward the first floor exit. He can almost taste his freedom.
This is where Bernard Neal makes a truly catastrophic decision. Fleeing from lawful custody, especially from a courthouse after being ordered into custody, immediately escalates his legal troubles dramatically. In Georgia, this is codified under OCGA Section 16-10-52 as the felony offense of escape. The statute broadly covers escaping from confinement or from the custody of a law enforcement officer. Neal wasn't just walking away. He was actively resisting, damaging property, and injuring officers during his escape attempt. These actions add further felony charges like criminal damage to property, OCGA Section 16-7-23, and obstruction or even aggravated assault on a peace officer, OCGA Section 16-10-24 and OCGA Section 16-5-21. What might have been a sentence for previous charges of theft and fleeing officers, exacerbated by a failure to appear, now includes severe penalties for a violent escape attempt. This kind of spontaneous, ill-conceived flight almost always results in harsher punishment and a longer stay behind bars.
But when the judge instead sets bond at $8,500, Davis reportedly fires off a barrage of obscenities. The judge orders Davis to be removed from the courtroom, and it's captured on security camera. According to the judge, Davis shouts an insult on his way out. That's when Judge Hayes decides
he's heard enough. He grabs Davis, who's cuffed and shackled by the shoulder. The judge then pushes Davis into the wall.
Here, we witness a profound breach of judicial conduct. While a courtroom must maintain order, and judges have inherent authority to ensure that order, physically assaulting a defendant, particularly one who is cuffed and shackled, is an egregious overstep. The Georgia Code of Judicial Conduct, specifically Canon 2, requires judges to, quote, avoid impropriety and the appearance of impropriety in all of the judge's activities. And Canon 3 mandates that judges perform the duties of judicial office impartially and diligently, maintaining patience, dignity, and courtesy. A judge's role is to apply the law, not to engage in physical altercations, regardless of how provoked they may feel by a defendant's obscenities or insults. This action demonstrates a complete loss of temper and control, which directly violates the ethical standards of the judiciary and can lead to severe disciplinary action, as we'll soon learn was the case here.
Next, we're in Atlanta, Georgia, for a protection order hearing. 53-year-old Rhonda Love has requested a TPO against Rietta Walker. Love claims that Walker has harassed her online and showed up at her house demanding money. Their connection? Walker has been having an affair with Love's husband of 7 years. Today, both parties appear remotely before Judge Alex Manning.
Miss Love, tell me what Miss Walker did to you, specifically what she did to you, please.
She showed at my house 3 times, once with a man and a gun in her car. My husband came to the porch and said, call the police, she got a gun in the car.
Tell me what happened, why she came over there.
Her and my husband know each other.
Had an affair.
Exactly, and it has been going on for some time. She has been calling me like the first of every month saying that he owes her money. She started talking like, this is me, tell that call me or something she said. But I don't want to get between her and his relationship. I've been knowing about...
Are you okay with the affair?
I'm okay with it. I tried not to break them up because I wanted him to go there, but he wouldn't leave. He's still here.
Oh, so you want him to leave you and go be with her?
Yeah.
Well, Miss Walker, let him come on over and live. What do you do? You don't want him that bad either, right, Miss Walker?
I don't want him there. There's too much drama and a lot of lies. I don't want him. I'm okay. I don't have a problem with her either.
Well, look at that, Miss Walker. She don't even want him. You can't even give him away. You don't want him? She don't want him?
The judge seems baffled by the situation, but things only get stranger as Love explains how the altercations nearly became violent.
She started to insult me. Then she left after I called the police. And then when she came back again, she came back with a butcher knife. She had that knife out in her hand. She is running around here with a butcher knife in my yard, slapping on my car. I really had to send a warning shot at her in order for her.
You fired a shot at me?
Yeah, I did.
This admission by Ms. Love is incredibly problematic from a legal standpoint. The concept of a quote-unquote warning shot is largely a myth in real-world self-defense law. In Georgia, under OCGA Section 16-3-21, a person is justified in using force, including deadly force, only when they reasonably believe it is necessary to prevent death or great bodily injury to themselves or a third person. Firing a gun, even into the ground, can be interpreted as reckless conduct, OCGA Section 16-5-60, or even aggravated assault, OCGA Section 16-5-21, because it can place another in reasonable apprehension of receiving a violent injury. Once a bullet leaves the barrel, it cannot be controlled, and the potential for unintended harm, or even death, is immense. The judge's immediate and stern correction highlights the serious legal peril that Ms. Love placed herself in. Instead of de-escalating, she introduced a deadly weapon, potentially escalating a verbal dispute into a situation where she could face felony charges.
Before making a ruling, the judge wants a little more information from Love.
So you knew he was a cheater when you married him.
Exactly. And I agree. Because that's our choice. I knew he was a whorish man. I knew he was. But that has nothing to do with how I feel about him or how he makes me feel.
I don't know. He would make me angry. Most people he would make angry. But here's the deal, man. I mean, you can't go out firing weapons, even if she is out there kicking you, kicking your car or doing whatever. Miss Walker?
Yes, ma'am.
Your mama, she must want better for you.
Yes, ma'am, and I am doing better. I'm doing a lot better.
This ain't some sister wives things. I don't know what y'all got going on, but there's a whole bunch of drama. Here's what I'm going to do, though. In 30 days, ma'am, this is going to be over. Ms. Walker, don't go back over there. This is going to expire on October the 23rd.
And I'm asking for my PTO. And I'm
granting it for 30 days, Miss Love. Miss Walker, God help you. You live in the same neighborhood. So if you got to pass her house, find another way out.
Okay.
After issuing the 30-day protection order, Judge Manning has a final comment for the plaintiff.
Miss Love, put your gun away. Because once that bullet leaves the end of that barrel, there ain't nothing you can do to control it. There is no such thing as a warning shot. You understand me?
Yes.
Next, we're in Atlanta, Georgia for a bond modification hearing. 38-year-old Tamika Ali has been charged with cruelty to children and simple battery after, according to police, she got into a physical altercation with her 16-year-old daughter. Ali was charged and released on $12,500 bond. As part of her bond conditions, she was ordered to have no contact with her daughter and stay away from the home. Today, Ali appears before Judge Alex Manning, hoping to have her bond modified for medical reasons. She's represented by a public defender, Hannah Rondon.
Go ahead, Ms. Rondon.
Recently, Miss Ollie has been diagnosed with cervical cancer and has started treatment. Being unable to live in her own home has caused her major issues with recovering. She's had to live out of her car. So we are asking for, one, the stay away order to be amended, and also for the no contact order to be taken away.
Rondon then brings up the Department of Family and Child Services, commonly known as DFACS, which had opened its own investigation regarding the incident.
It's my understanding that that DFACS case has been closed, and that it has been closed because the allegations from the child, she admitted she made them up. I was told DFACS was going to be on here to speak to that.
Is anyone from DFACS here?
Since no one from DFACS is on the call, the judge turns it over to the prosecutor, Celeste Patton.
My position is to object. If Your Honor is inclined, I would like to hear from the minor child. I think she is on here.
All right, can you turn your camera on for me?
The alleged victim appears on the Zoom and is sworn in.
Will you tell the court whether or not you have stated to DFACS that this incident did not actually occur? Did you hear my question?
If you're close to somebody, you need to get away because there's feedback.
Mm-hmm.
When mother and daughter both move to avoid feedback, Patton and Judge Manning come to a realization.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
The judge
This is
is
an
not
instant and undeniable
So right now, what you're
violation
telling
of
me
a
is you're
fundamental bond
violating your
condition,
own bond
the no
conditions
contact order and
before
stay away
I say you
order.
can amend
In
them.
Georgia, bond conditions are established under OCGA Section 17-6-15, which grants judges broad discretion to impose conditions necessary to ensure the defendant's appearance in court and, crucially, the safety of victims and witnesses. A no contact order means precisely that. No contact, direct or indirect, and certainly not living in the same home as the alleged victim. Ms. Ali's attorney was attempting to argue that the DFCS case had been closed because the child admitted to making up allegations, which might have been grounds to modify the bond. But by appearing in court with the alleged victim in the same residence, Ms. Ali has not only demonstrated a disregard for the court's authority, but also severely undermined any argument for her trustworthiness or fitness for bond modification. The prosecutor's immediate objection here is absolutely warranted and highlights the brazenness of the violation unfolding live before the court.
So, Miss Rhonda, I tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ali, and then put it back on for another motions hearing.
Your Honor, I do appreciate that chance.
Thank you, Miss Rhonda. Best of luck to you, Miss Ali. Have a good evening. But you need to leave where you're at.
2 months later, Judge Manning agreed to modify the bond and allow Ali to move back in.
These cases offer a stark reminder of the complexities and sometimes explosive nature of the legal system. In the case of Bernard Neal, his desperate courthouse escape led to him pleading guilty to his original charges plus felony obstruction, simple battery, escape, and interference with government property, resulting in an additional 5 years, bringing his total sentence to 10 years in Georgia's Lee State Prison. For Judge Carrie Hayes, while no criminal charges were filed, the Georgia Supreme Court suspended him for 30 days without pay and ordered a public reprimand by a superior court judge for violating the Code of Judicial Conduct. The underlying charges against Brian Keith Davis remained pending. Regarding Tamika Ali's bond hearing, Judge Manning initially denied the modification request after witnessing the bond violation, but 2 months later agreed to modify the bond and allow Ali to move back in, likely after conditions were met or new information was presented. The ultimate disposition of her cruelty to children and simple battery charges is not publicly available. And finally, for Rhonda Love and Rietta Walker, Judge Manning granted a temporary protective order for 30 days, sternly warning Ms. Love about the dangers and illegality of firing so-called warning shots. Information on any further proceedings for this specific protection order is not publicly accessible beyond the initial 30-day order. These moments remind us that the courtroom is not just a stage for legal arguments, but a place where lives and reputations can change in an instant.